Perfect, just on time. Awesome. So we'll give a couple of minutes for all of the viewers to join our webinar. I think that's the hottest topic we've ever had here, plus the amazing speakers. So I'm sure that there's going to be worth listening to it and asking your questions for sure. So we'll give a couple of minutes, for the viewers to join an event, and we will start then. All right, so I see people are coming in, so we can start slowly and get to the hottest agenda of the first half of the 2026. So the topic of today's I wanted to say episode is MiCA. I think that's the hottest topic on the market right now, especially for the European-based crypto companies. And me with my speakers would share with you today some kind of insights and thoughts in regards to what should you do or what are the next steps if there's no MiCA license yet at your company, and how you still can operate and launch your crypto exchange to provide crypto services to your existing customers base or to your upcoming customers base on the territory of the EEA countries. I have Joonas today. Joonas is a co-founder at Kvarn, the crypto company that received MiCA license in the Nordic countries, Finland to be exact. We also have Nikita today, a FinTech lawyer with a great and big experience in that particular niche. So I'm sure that we have a decent people today on the webinar, and we would definitely highlight all the topics that we want to, and all the questions as well, for sure, that you are guys gonna send us in the chat. So please stay active, share your comments, your questions in the chat at any moment of the time. We would cover them at the end on the Q&A session, where we would definitely make sure that we cover all of the questions with our answers in the full spectrum. Right, that's a short agenda, but I'm assuming we have a lot of things to cover today, so I would jump straight to the first point that we have today, and to be exact, that's the MiCA transition deadline. The main question is what's going to happen next after the June 31st. Nikita, that's probably the best question to you to be covered. Please, the stage is yours.
Thanks, Karym. Again, thanks for the invitation. Very great presentation we're going to have for you guys today. I will try to make it as clear as possible regarding the question of the deadlines and transitional periods, which were outlined in MiCA and now followed by most of the countries in the European Union. Not all of them, though. So the transitional period ends basically under the Article 143 of MiCA. The deadline would be July 1st, 2026. This is a hard stop, which means that the company the countries under MiCA had some discretion which transitional period for the deadline for the MiCA license to apply. Um, Obviously, there are some countries which had some licensing before MiCA in place. Those companies that had WASP licenses or DASP licenses, like in France, they um, they are able to operate uh, some time after the MiCA is enforced, but this time is not unlimited and it's maximum up to 18 months. And these 18 months are ending this July 1st, which which means that countries and no other licensing regime will apply in European Union. Only MiCA, only CASP licensed entities would be able to offer these services in Europe and would be able to facilitate the transactions in crypto for the clients in Europe. There are some countries which still had the longest transitional periods in Europe. Those are France, Malta, Luxembourg, Estonia, Croatia, and some others. The other countries like Netherlands, like Latvia, Austria, Ireland, they have already uh, the deadline is already like last year, or it was 6 months transitional period. So those are gone already. And so following the question, yeah, we will see that no operations would be possible starting from the July 1st. Coming back to the second question, that which is uh, probably the most important one, it touches the responsibility and the risks associated with operations of the companies that do not have a proper MiCA, we call it CASP, authorization in Europe. I have some. There already been cases. MiCA itself explains that it's an article 111. You can check it yourself right now. That there are fines for both legal persons and natural persons, which for the companies that operate without the
mm,
proper authorization in the European Union.
mm,
And these fines are not abstract. We can say that they can come up to 5 million euros, or they can come up to 12.5% of the total annual turnover of the company
mm,
in case there are some issues, some serious breaches of the MiCA regulation. And in fact, there were some cases already in place. There were cases with Bybit FinTech. They were issued a fine for 2.2 million euros by the Netherlands regulator, Dutch regulator, in 2024 for operation without no authorization, no registration. Same thing happened with the OKX, again for the August 2024. Same number, 2.25 million euros. Same
mm,
thing happened to Cryptocom. They also got fined for almost 3 million euros for operating with no registration. So these guys, these fines are real. They would be more and more in place, and that's why I'm saying that there are some serious risks, not just your banking providers or your EMIs banks would stop working with you. This obviously going to happen after July 1st. No banks or EMIs will support any WASPs in Europe after July 1st, since the transitional period ends, and they all require. We already seen that they all require CASP authorization, not just the applicate proof of the application, but they ask you for the final decision on your case. And yeah, just coming up short, there are some specific cases. There are some specific jurisdictions like Poland, which doesn't pass any legislation, and there are lots of WASPs in place. And probably there are lots of hopes for this jurisdiction where, since there's no MiCA, uh, there is no law which transitions MiCA into the local registration, the WASPs could operate after July 1st. The short and very definitive answer would be no.
mhm,
And this specifically means that after July 1st, and there is no legislation in place, uh, there is no company which could operate and provide crypto services in Poland, um both to the Polish citizens, to the Polish people, or to the other countries in the European Union, which basically means that no companies would be able to operate from July 1st from Poland.
Mhm.
So this is, guys, this is what it is. Gonna pass the micro.
Yeah, just to summarize here, that really means that we have less than 30 days until, I would say, a controlled, but still, if I may call it, collapse on the territory of the EEA countries in regards to the crypto companies. Because from what we see here at Simplify Labs is that a lot of the companies still are, unfortunately, are acting as a non-serious in regards to the MiCA and what's going to happen after the deadline that is dictated by the regulator itself, which is July 1st, which is a hard stop. I'm really curious from a good point of view, of course, to see how it would affect the market. Starting from the July 1st, as well as the companies that are still in the territory of the European Union without the MiCA license in place. So yeah, I think that less than 30 days until we see an action in place, and we'll probably find out whether the big players on the market would take over the game, or there will be the cases where definitely a smaller companies comparing to, let's say, Kraken would still start taking serious those things about the MiCA and the regulation field that we are in terms of the European market. The next topic to cover is probably how to launch like logical. If we thinking about the whole scope of the situation that are we in right now, the logical part most probably is how to launch your own crypto company without the MiCA license and still be able to operate on the territory of the European Union, because we all know, guys, that in order to apply for the MiCA, in order to get MiCA, you not only have to be legally sustainable, which means that you need to follow all the rules that are in place by the regulator, but you also need a nice and good sustainability in terms of the finances, which can be like your internal financing or external, which are, I don't know, the investments, etc., etc. That's probably a good point here to cover, how to launch your company without your own MiCA license. Joonas, if I may share the word here to you to cover this topic.
Thank you very much, and pleasure to be here as well. And quickly, just for the context of the background, I open up a little bit how Kvarnex is related to this. And yeah, basically we are based in Finland, regulated by the National Financial Authority on three different elements. So we have a Kvarnex platform affiliated entities, we have a CASP license, we have PSP license, and then we have also the MiFID II traditional investment service license. So we do cover a little bit more than the purely the CASP or the crypto side as well. But sharing the practical experience from our side, given that Finland and Netherlands and some other countries chose the 6-month transition period. So we were living this same period a year ago in Finland and Netherlands, approaching the deadlines of the transitional period locally, our national level, and their the experiences, what we needed to prepare. We were operating as a WASP before that, so we were in the WASP regime. We were basically obliged to apply already well beforehand if you were planning to upgrade from the WASP registration to the CASP license. So for us, the preparation started already 10 months in advance of the July 2025 deadline. So that was the experience from our side, and still we we bypassed the timelines in Finland in the context of the applicants here because of the certain bottlenecks in the handling, and because it was a very tight schedule from every party point of view, that we chose the 6 months. Most countries chose the longer ones, but now we are facing the very final deadline, as Nikita pointed out, in the last EU countries as well. So that's basically the practical background how we are here today. And as we know, we also had the same issue a year ago, that the regulators were asking also the questions of how would you plan your continuity after the deadline, how you do your wind down plans, how you client migration plans, and so forth. And we went exactly this same path back then. And basically, I would say not from the legal point of view, from practical business point of view, Nikita can be more specific on that. But the issue with the MiCA regulation specifically is that you don't have this kind of agency model, which is traditionally recognized under the payment services or the investment services. So it gives a little bit more, and there is market practice, over the years of operations. And with the crypto companies now, this kind of agent delegation model there wasn't any practices back then. Now it has been a little bit formed over the last 12 months and so, but at the same time, the options basically would come down to the 3 different paths. One of which is that if you have existing client bases, you need to find a new home for them, meaning that you would migrate the client base to a provider who has the CASPA authorization. You retain some commercial aspect of those, most likely, and then you continue the business if you may have some other businesses on top of it as well. The second option would be to find a partnership model underneath the regulatory flexibility, which is strict as pointed out, and here we are talking about kind of a gray label or white label models, where basically you somehow utilize the partners who have the license, but then again you retain some branding element from your side or existing branding and the businesses. And the third option would be then, of course, to still pursue their own application, but now given the timelines and of course the regulatory bottlenecks in each of the countries, because the number of applicants is very, very high. Realistically, within 30 days, you would need to find some solution and also pursue those alternatives. And of course, the regulators have been. I'm assuming that they have been asking about of course, the continuity plans already well in advance. So the plans need to be there in place. But practical level, it's not easy to find a good solution, but it is possible, given that you are prepared for that, and you also plan well ahead how and how you want to operate. And of course, a specific business point, that do you have existing client base? Are you planning to just launch in the future and so forth? So that's those are the practical considerations that we also faced a year ago.
Right. Yeah. I see the question which I want to cover right away in the chat on the white label. The people are asking to be, let's say, more specific. So the white label, if I may to cover this question, is the model where you operate under your, let's say, individual brand with the hard disclaimer that all we would be covering these steps further in our conversation, but that's in white gray label. I like this wording, Joonas, to be honest, because that's probably the most correct wording for in this case. That's when you have your own brand, but all the let's say operation with the clients and their funds are under the umbrella of the MiCA regulated CASP which allows you to still exist as a brand on the market and have a place where you can onboard your clients without having your own infrastructure, your own licensing, and your own let's say team of the individuals like compliance, legal, etc., that are necessary to allow you the runway of your company, as well as the business plan and everything Joonas and Nikita covered in the previous slides. However, we would dive deeper into that topic a bit further, just to highlight in more details. And that's where we started talking about that, which is the fast track exchange launch with the white label infrastructure. I'll start here first, if you don't mind, guys. Look, being in the fintech business for quite a while already, the main pain point that we see ourselves as a business out from our clients is when you invest a lot of the funds into the software or the process itself, and it doesn't go well because you don't have the proof of concept, for example, on your end. You don't have a success track of the things that you are developing internally, so you just spend funds without the proper return on the investment, because like your assumptions was A, but the outcome is B. And that's the biggest painful point on the current market, which runs at an amazingly fast pace currently. So what Joonas covered previously, that we are at the very deadline of the MiCA grandfather period. So there are less than 30 days, and there are thousands of the VASPs on the market that would most probably, unfortunately, would not receive CASP conversion at the end of this period. And the logical question is how we can operate or re-onboard all the clients without having a MiCA. One of the good points that Joonas covered is to find a proper partner with a CASP license, where you would just delegate all the clients to as an affiliate model, let's say, or the referral model. However, you still want to be present as a business, as a brand, and that's understandable because you've already invested a long runway and the funds into your own brand, and you still want to operate on the territory of the European Union. And that's where the idea of the white label, gray label, may I say, was born. So in order to answer how the white label crypto exchange would work, we need to dive a bit more deeper into the principal understanding of the regulation. And the simplest way to explain it is you act as an individual brand. However, all the operational activities, which is registration, KYC, KYB, financial operations, which are deposit swaps, accessibility to Euro market, fiat markets, or to MiFID tools, should be done by the VASP itself. Which means that on the front end, if I may, on the storefront, it may be brand XYZ. However, on the back end, all the operations, all the things that are happening with the clients are going to be happening through an existing CASP company, which is in our case, Kvarn. And here I want to pass Joonas a word on how they are starting to process these thoughts, how we came up with this idea together with Simplify Labs and Kvarn on the gray label option for those CASPs that are existing on the market currently.
Yes, and basically, given those circumstances, I would ask also Nikita to outline some of the non-negotiable terms under the MiCA as well. But basically, the basic principle would be that the gray label, meaning that both brands need to be visible there, meaning that even though the CASP is sitting in the background when it comes to basically all the processes, it needs to still be quite visible in a way that it could be, powered by X, or in collaboration with X. So
or all the services are provided by.
Yeah, and it needs to be very, very transparent on that side, because if you compare, let's say, just in comparison, you have quite established model for the, banking as a service, or payments as a service, or even the investment services to some extent, operating fully on an API based. Usually the terms and conditions are somewhere in the background, right? But now in the context of the crypto asset services, and how the MiCA regulation is the stance currently says is that this gray label model, where both brands are visible and there is no kind of misjustification that who is providing these crypto asset services, that needs to be very clear. So that's limits a little bit more than you have in the other financial service sector. What is the flexibility of doing things and so on.
Right.
But Nikita, you may have the legal basis for that.
I'll give a little bit of background on this topic, because it's very correct that you mentioned that in the PSD2 we have exactly Article 19, which says that you can be an agent of someone and have this banking as a service. It's all legally possible, right? And there is no such thing in MiCA. And some people reasonably asked ESMA, what should we expect, and is it okay to work with the agency models as alternative to and the same thing as in MiFIDs or PSD2, and ESMA actually gave a little bit of restrictive answer. It was 2024, I believe. They said that provide the crypto services could only the person authorized under the Article 62 or 60 of the MiCA, and no one else. However, so this answers straight away that pure white label is not possible. You
Right.
cannot you can hide your provider somewhere else on the background. It is not something we can do. Therefore, so the gray label is it could be done, because nobody prohibited other service like distribution of services, nobody prohibited marketing and other types of partnership which you can frame your cooperation with the authorized CASP, right? But again, as Joonas very correctly mentioned, it has to be so explicit, so transparent that nobody has any questions how it works. We're going to cover it later on the slides, but I just give you a little bit of summary. It has the disclaimer should be very visible and explicit on the way you describe your business model, all the responsibilities regarding the AML, KYC, holding of the funds, doing the transfers of crypto yourself, exchanging crypto to fiat should be performed, and also it all has to be done by the authorized CASP, and they also and we need to be explicit on that. So these guys are doing the AML. We're not doing AML ourselves. All the responsibilities, all of the rights and obligations are on the authorized person, and yeah, that's the way it could work. But however, I'm gonna get back to it a little bit more in details later on the slides, because there are some peculiarities you would want to work with.
Mm-hmm.
Yeah.
Perfect. Thanks. That's why I'm saying we have a great team today, covering all of the aspects. That's the best thing to have. Yeah, I fully agree with you, colleagues, on that. Taking into consideration the restrictiveness of the regulation itself, plus what we are trying to achieve from the with this regulation to be so the crypto services can be more accessible and more safe for the retail clients, more accessible to the businesses that want to enter this part. That's definitely something that we need to take into the consideration. I think there always will be some obstacles which we need to work with or work on during any type of the new achievements. However, we have a good examples of how it may work, taking into account, for example, a great example of the Zero Hash US-based company that's offering pretty much the same business model, not completely the same, but very alike business model on the territory of the United States. We've been in talks with them in regards to like find out what they're offering with for sure with our clients, and that really makes sense. So we see this is already applied on some parts of our globe, and I think that's something that can be or will be for sure replicated for the MiCA regulated CASPs. I'm going to go to this next slide where we would definitely cover more of the legal aspects and compliance considerations in regard to what we've discussed previously. The best person here to start with is Nikita for sure. So Nikita, please, the stage is yours.
Perfect. That's exactly what I would like to cover right now. But you guys, please feel free to ask questions. I'll try to make a full answer as full as possible, right? So the first thing first is that, as I said earlier, this is all sort of, there is no official, like, in the UK, they have financial promotions when you can provide crypto services sort of with the agency or white label model in the UK, no problems and no questions asked. Here, you don't have that one. And as I said, you have to be very careful not to get fined, because no one outlines the way it has to be done. So we are doing our best to be as explicit as possible, to be as safe as possible while working with this type of models, and that's the way it works. Again, the first thing first is that compliance is essential for the operators. Of course, the first thing is that the CASPs authorized under MiCA are responsible for everything, frankly speaking, and there is no other answer. The guys which would use the gray or gray label, so-called, right, not a fully white label, we're not going to bear any responsibility for the operations. They could not do that. There is an explicit prohibition of delegation of the responsibility of the AML, custody, and other services in MiCA. Therefore, again, coming to the second question, AML onboarding, reporting obligations, all has to be done by the authorized entity, which is, in that case, Kvarn, but it could be any other.
Mm-hmm.
These guys should be doing everything. What are the principal parts right here and what we should mention? You could, in fact, frame what we will do for you guys, and as soon as you come to SBSB with the question, how do we frame this cooperation? There are some ways to do that. You can frame it as marketing, as lead generation, as a front end, as a development. You can have some sort of customer introduction place where you say that we provide this type of assistance with the customer introduction. We have some clear marketing of these services, and even though they are provided by the authorized CASP, explicitly mentioned, and I would recommend having on the website, when you enter the website, there is a disclaimer on the website which says we work this way. This is authorized people. They have this is the number of license. Do you agree that you have read everything on the descriptions? And as soon as your client or your lead clicks agree, we can assume that these guys read the instructions. They are aware that you are working with this model. We call it an explicit explanation of the system. And then after that, of course, you can work with your UI, you can work with your soft to make it work right, use some platform capabilities to process the payments, do transactions, and all of these type of things. Also, of course, on the website, we recommend mentioning it outside of the box that is shown to the customer. On the terms and conditions, it's mandatory. disclosure of the language should be very plain and readable, understandable also on the footer of the website, etc. The contract, though, with the CAS provider and with the service provider, which is not authorized, right, which using white label, has to be very, very carefully structured. And all of these things we consider case by case, but just to give you an idea, the whole expression is that since there is no regulation for that, there is no permission to do so, we need to be very careful and very, again, thoughtful while planning this type of cooperation.
There's also something that I always keep in mind. If there is no, if the rule says that you can do so, it doesn't mean that you cannot do the other way, which is not described in the book. I do understand that, Nikita, for you it may sound like a red flag, but I'm trying to think as a businessman, an entrepreneur. So sorry about that. But yeah, I absolutely agree with you. There should be an absolute transparent communication between the CASP, which is an authorized entity, and a not authorized entity in regards to the cooperation that they are starting, and as well as the communication with the end user. Even with the marketing materials, I assume that there's also should be a big disclaimer that, hey, those services are, at the end of the day, are provided by, and here's who responsible for everything, and so on and so forth. Well said, nothing to add on top of that. If we covered all of the, let's say, obstacles or aspects of that, there is a final question on the how to make it happen, how to practically go to the market with this type of the strategy, and which strategy at the end of the day, is the most common or convenient for those FASPs that are at the end of the grandfather period. Joonas, either you or I would cover this, but I see you you're a bit bored because me and Nikita we talked for the past 5 minutes, so I'm passing the word to you.
Yeah.
People want to hear you.
Yeah. Thanks. No, it has been very, very interesting, and Nikita's point, because it's as said, it's a case sensitive in that way as well. That what kind of situation you may have. Do you have other licenses or only WASP and so forth? So I think you need to assess it case sensitively as well. That what kind of circumstances you are starting off, and I think for the current WASPs that would like to maintain the client relationship after the transition period end. Of course, the time is a little bit already stretched, and basically, if you are applying for the CASP, you should have already planned ahead something also towards the regulators, most likely. But now the practical steps, of course, would be that what kind of a business plans you have in mind. Do you many have invested a lot of money in the technology, on the client base growth over the years, all the operations. So how much value is sitting there? Do they want to maintain those, or are you looking for some kind of commercial exit from the client base as well? So I think those will determine a little bit where to go with the road as well. And on the of course, the quickest and most straightforward thing would be to just onboard the clients to some existing platforms with some kind of a commercial model. That would be very quickly done as well, because the migration sets the deadline for or the deadline sets the migration deadlines for the client bases. The grey label model, of course, then needs to be assessed against the case and the brand values and so forth, and how to basically arrange that re-onboarding of the clients and so forth. So I think those are the practical steps. If you are not already well in advanced discussions, of course, the timing is very critical because of this deadline approaching. And then the third one, of course, that is there basically something else in the business that the cryptos are just about to come to the business, and that a little bit more, further down the road once the MiCA regulation sets and so forth. But in a sense, if planning is to start a new business with the new, onboarding clients to cryptos as well, you can assume that now the application periods are extended because of this, bottlenecks from the regulator. So if freshly start to apply for the future business, it might take, I don't believe that you will make it within 6 or 9 months. It will take rather, 1 year or even more. So the practical solution would be to collaborate or find a partner model with the existing CASPs there as well. And one final comment, not to kind of bring too many complexities, but what we have experienced also at the practical level is the stablecoin side of the business, which are now considered as EMT, e-money tokens. And now it is quite clear now that if you handle stablecoin transfers within the EU, now the MiCA CASP authorization may not be enough to handle those. And now you are also required to have the PSP, Payment Institution License, or PSD2 license, in order to only transfer those. So we are getting the overlapping regulators in the EU, which of course no one was. I think the intention was to do this overlap, but now it's actually the case, and we've seen a lot of also platforms that they have stopped processing, for instance, USDC transfers because they don't have that authorization. So it may not be anymore just a CASP, but it may be that you need to actually have this kind of a dual licensing framework as well. So
yeah, well said. To sum up also here, if you are an existing business, as Joonas said, you definitely need to reevaluate all the investments that you already made into the structure, the team, your fast runway. If you are a new business that is looking to enter the European market as a crypto asset service provider, then for sure partnership in any case is the best option as a go-to market strategy with a further assumption of self going for the MiCA by yourself. However, as Joonas as well said, and what we see from our clients that we are working with or partnering with, MiCA is not a quick process. So it's something that I would say it's a type of business that requires a lot of previous background, which is probably super important in this case. In the let's say European on the territory of the European market and licenses that are close to MiCA, so-called, as well as the previous technical experience, because the infrastructure that you need to have is enormously hard. Let's not forget about all the KYC, KYB, which is the simple stuff, as well as the AML. However, when we're talking about the KYT, all the aspects that may have in terms of the thresholds of your clients and their KYC profile, their activity on the market, some sort of a red flags that may appear during their trading session, so-called, or trading history on your platform, the requirements to the platform itself, to the custody of the funds, to the funds management and custody management. That's a whole different big story. I assume we covered all the topics that we wanted to. Now I suggest us to jump to the Q&A session. I have Daria, huge shout out to you, who collected all the questions in my DM from the chat. So I'll go ahead and cover and read them, of course, one by one. Then we pass the word to Joonas or Nikita, depending on the question. So first question, Nikita, I understand you're already at the final stage of obtaining the MiCA license. Could you share how long you've been working on this case and what challenges companies face in the practice. I'm very interested in hearing not just the theory, but the real world experience. I think, Nikita, that's the great topic to you. However, Joonas, as a person who received the MiCA, is also would be good to hear from him.
Yeah, I would, Joonas also mentioned, and it's quite right what he said, that it's not easy and it takes time. It could be over the year. Practically speaking, to get the license from someone who has never been in the business before, who had never had any MiFID licenses or PSP licenses before, and just get the MiCA from scratch is something that is, and also which is purely crypto, is very difficult procedure. Just for the reason that we've seen, and if we compare PSD2 or MiFID with MiCA regulation, everything for crypto is much more difficult than for other authorizations and licenses, just because crypto is considered to be high risk, etc., etc. Though you can get authorization much easier if you had some previous authorizations or licenses. Banks in Germany got lots of authorizations. We've seen that in Spain, 3 banks got the previously authorized with very ease. And therefore, getting MiCA from scratch would be it is a big deal. That's why I do recommend having some partnership in place, at least for the newbies on the market in Europe. Could you confirm or or give some opinion on that, Joonas, from your perspective?
Yes, I agree on that, and I think the expectations also, once we saw the MiCA draft back 4 years ago, it was that it will lead to consolidation in the sector, heavy one, and most likely tilted towards the bigger players, established players, like you said, who has this kind of power in the background as well. And now we've seen, if you look for the interim register of ESMA maintained by the CASPs, you see that it is quite heavily tilted towards the Germany, for instance, with the big financial institutions dominating the meaning that they have established business models and so forth. And part of that is also that under the MiCA you can do this so-called notification path as a financial service provider, like a credit institution or bank, investments service provider, which is a little bit lighter, heavily reliant on your existing business and setup there as well. But if you start off with a fresh start, I do agree that it is a very tough path without any experience, or if you don't have any kind of related businesses with other financial services like the payments or the MiFID II stuff. So it is a heavy one, and one practical example which is still ongoing is that because this is very new regulation, there is basically every month coming some kind of a clarifications to the regulation. So in the application process, there was, I would say within our timeframes, there was at least 6 or 8, 10 times becoming new clarification from the ESMA level, which were changing already the ongoing application process. And this was a year ago. Now we still see those, right? And it's changing the how the regulators are perceiving the applicants as well. So it's a little bit of never-ending story, or kind of running train that you are trying to catch up there, because the regulation is so new and it's adapting quite heavily. So it's that's one of the issues, because then the PSD2 or upcoming PSD3 or the investment service MiFID II, it's established regulation. It's quite clear that what you can do and what not. But this is one of the challenges that for the MiCA new applicants and the current applicants, they are facing constantly.
Right. Yeah. So the second question that we have, thank you, colleagues. The second question that we have is, does the app decentralized applications owners should apply for MiCA license for providing token, not services? That's a good question, though.
Let me address that. All right. As for the question, guys, decentralized platforms which are fully decentralized are exempt from the MiCA regulation, which means that you are not entitled to obtain any sort of licensing. You can easily operate if you do not do any custody, if it's fully decentralized. You are free to go. No limitations, no problems. The simple answer would be that. But of course, in
Yeah.
each case, we need to make sure that your platform and application is fully decentralized in that way. And if it's so, you are exempt from the license.
Yeah, I assume that well said. I assume that if there are some additional add-ons that are, let's say, pointing to some sort of custody, yeah, that's for sure regulation in place. However, yeah, the app, just like with the app stores, App Store, the app is a software where there is no custody, means that the risk appetite is fully on the client side. So just like that. What about the VASP? Based outside of the European Union, operating under a reverse solicitation model? That's a good question we covered on the previous webinars. However, Nikita, the floor is yours.
Yeah, I believe I've already been addressing that one. If you guys can share also the link to that webinar for the guys, probably we have been speaking about it for more than a year, for more than an hour. So simple answer is that reverse solicitation principle applies to the VASP outside Europe, and in theory you can work, of course, not directly from outside with the European market. However, again, reverse solicitation is much stricter, and we see that in practice in crypto world than it is in other worlds when it's investments or payments. So when you do reverse solicitation, you have to be very careful. How do you structure it? So you have to register each of your client which comes from Europe, and you have to be able to prove that they contacted you first, not you contacted them with the marketing and etc. etc. So there are lots of peculiarities. I think we've been covering that earlier, but simple answer, yeah, you can work with that with principal reverse solicitation.
But guys, not 100% of your clients should be from the European Union when
Yeah, that's
you're.
a huge red flag.
Yeah, that's for sure. So there's definitely some sort of a percentage that should be always kept in mind. Like that's why it's reverse solicitation, not vice versa. Thank you, Nikita. Going to the next question. There's a question. Let's, for an argument's sake, we developed an ecosystem to allow our clients to build white label or great label DApp solution. So at this point, who should get the license, VASP or MiCA, the technology provider or the DApp manager company? Well, I assume that Nikita covered this question just a minute ago in regards to the DApps that are acting as an exception from the MiCA regulation. Nikita, please correct me if I'm wrong.
A simple answer, you would not need to have any license in that case, since you're just building software for some people to use this type of models, right? Again, as soon as you're not engaging in the services directly, if you have a right partnership, everything is structured and legally is correct, guys, just giving you my frank opinion. Of course, white label or gray label is great solution, and I can second that. It's easy way to get to the market, not waiting countless months to get the license, right? But also legally structuring it so you're just not getting a $2 million fine for doing almost nothing wrong.
Yeah.
So yeah, in simple answer, no, it would not require a license, but again, if you're doing everything correctly.
Thank you, Nikita. I hope that covers the question itself. It clears for me, to be honest, though. What about a self-custodial wallet that integrates an on-ramp and off-ramp solution, but where the use of that solution is entirely optional? So, guys, on-ramp and off-ramp in this case comes as a feature that is provided by your partner, which is on and off-ramp provider who already have their licenses in place, and that's up to their risk appetite and, let's say, up to their AML policies, KYC policies, etc., on who they can onboard and serve because your D app might have clients from the whole world, but on and off ramp provider, they should either get their own risk appetite when serving your clients, so they may not serve some, I don't know, European-based clients if they don't have a required license, and vice versa. You have a lot of other software providers that are combining on and off ramp providers underneath. So that gives you a full spectrum of the coverage globally. But yeah, that not affects your D app. That's more of a partner or feature that you have, and that is provided by the third-party partner with their own licenses. Question number 6, please drop some light on reverse solicitation service scheme of European citizens by non-European companies. Will this scheme be challenged after the 1st of July? And Nikita, I think Nikita covered this question on 100%. Guys, reverse solicitation is not a magic pill. In this case, yes, it can be applied, however, with those nuances that Nikita mentioned. So please be really careful with the reverse solicitation. It's not an option to operate under this, let's say, framework, under this framework.
Yeah. Just to add on that, one step wrong and you are in huge danger. For example, if your website in in Polish, or if your URL ends with like some specific ending, like a FR for France or others, that's a huge indicators. There are lots of them in the reverse solicitation. That's what makes it so much more difficult comparing to the FinTech and MiFID. We've seen, I don't know why exactly, but they made it much more difficult to do the reverse solicitation comparing to the other traditional industries and spheres.
Thank you. Yeah, thank you, Nikita. The next question is, can you talk more about FASPs that handle both regular crypto and stable coins and their licensing requirements? Joonas, that's probably the best question to you.
Yes, and that was the reference for the recent interpretation that if you transfer stable coins, which are now not considered, they are considered EMT, so e-money tokens, basically under the MiCA regulation. They are strictly payment instruments in that sense. And if you process those, if you custody those, like most of the crypto service providers do, right? It's a very basic business for all of us, right? But if you transfer those in and out of clients and custody those, now the interpretation within the ESMA and the EU is that those are considered strictly as a payment services, not, even though you have we have the CASP and we have the custody, we have the transfer services, we still need to have an overlap specifically on that particular use case covering from the PSD2 side, which is of course causing now this kind of issues with the existing CASP as well, that how do they continue serving those EMT token transfers and so forth. And now this was basically, I think it was end of February this year that they came out with this, and now even this kind of a transformation period, which is not official, but they get the deadline that you need to solve it out somehow. And now the national regulators are also asking and applying that to the CASPs. So basically, if you handle stable coins, you would need to now, with the current interpretation, have also the PSD2, either by yourself or with the agent model, or kind of a partnership with the current or existing PSD2 provider. So that complicates a lot of the stablecoin payment processing. And Nikita might have the correct legal basis for that as well, but that's on a practical level how we have observed it.
That's 100% correct. I can just add that so not all of the operations with stablecoins are oblige you to have 2 licenses. So there, of course, I believe last year in summer there were this non-action letter which explained that you have to have 2 licenses. It should be a payment license and it should be a crypto license to work with stable coins. But just to sum up here and give a little bit of more precision, only services of custody of these stablecoins and transfers of them would consider to be payment services, since EMTs are electronic money in the understanding of EBA. However, on-ramp, off-ramp itself, if you do not do custody, would not require you to have to both of the licenses. If you do only crypto exchange, crypto to crypto with stable coins, any of them except for like USDT you cannot work with because they are not authorized. But with all the authorized stable coins, which you can do you do a crypto exchange or crypto to fiat exchange, you would not need to have a second license. That's very simplified, but it's what it is.
Perfect. Yeah. Thank you, guys. I would skip some of the questions that are related to, again, reverse solicitation. The last one, probably. The last question. When it comes to NFT marketplace and DAO, I also assume that these are the non-custodial DApps, which are not requiring the MiCA license to operate on the territory of the European Union.
If I might add,
Sure.
I
was waiting for it.
It is 100% correct. NFTs are explicitly outside of the under the exemption of MiCA. So, of course, NFT you can hold, buy, sell, marketplaces, OpenCR legally can operate in Europe. The only thing is that some companies might use NFTs to structure and sell their tokens, which are not non-fungible in its principle. Those are not under the exemption. So only real NFTs under the exemption of this regulation.
Yeah.
Same applies to DAO. These decentralized organizations, still no regulation needed.
100%. Guys, these are all questions that we've had from the level of the market gossip. Is MiCA 2.0 is expected in the short future?
That's a huge question.
That's for sure.
I can address that. We know that there is PSD3 expected, and there are drafts, and it should be in place. And there will be a huge new way of looking at payment services. And I think we're going to need another webinar for that. At this point, we will not expect any MiCA 2.0 because this is a very recent regulation. Frankly, it's very explicit, very recent, not very bad. Doesn't have any significant gaps to be covered and to be fixed in the next regulation. And again, this is compared to the directives. Regulations are very hard to pass. These are legislative acts. They are directly applicable in any member state, and much harder to apply because they need to be commissioned. Then there is European Parliament, and they need to both agree on the final text. There is a huge process how it's done. It's much more easier to do the directives and the redo directives, as we've seen with PSD2, with PSD3, probably much easier than the regulations as MiCA. Therefore, I would not expect it in the short future. Neither I would expect it in the long future, frankly.
We need to find out how to deal with the MiCA 1.0.
Yeah, it is true.
And only then talk about the 2.0 version of it. Guys, my name is Karym, the CEO at Simplify Labs. It was an amazing webinar with Joonas, the co-founder at Kvarn, and Nikita, the FinTech lawyer at SBSB. SBSB.
Yeah, we'll call it SBSB. Yeah.
SBSB. Please feel free to book a call to cover some sort of a strategy session with Nikita, Joonas, or me in regards to the topics that we've covered and above that. So you're going to have a saved version of this webinar, today's webinar, on the YouTube on our channel. Simplify Labs was as always, happy to share with you some insights from the market, especially with such an amazing people that were today with me. Thank you all and have a wonderful day ahead. MiCA all. Have a good one.
Thank you.
Thank you very much.
Bye.